Westside Community Schools versus Bridget Mergens of 1990 was a Supreme Court case that broke barriers for certain student clubs. So, before discussing the details of this case, I would like to provide background information of what led to this case. In 1985, Bridget Mergens, a senior at Westside High School in Omaha, Nebraska, asked the school's principal, James Finley, for permission to form an after school Christian student club. However, James Finley denied her request. He stated that a religious club would be illegal in a public school because they could not sponsor them nor pay a faculty member to facilitate it. Therefore, Mergens decided to appeal the principal's decision in the federal courts. She argued that the school's denial was a violation of a 1984 federal law requiring equal access for student religion groups. The 8th U.S. Circuit Court of Appeals declared the principal had denied Mergens her First Amendment right to freedom of religion. However, it did not stop here. This case was taken a step further because the school district appealed to the Supreme Court. This became the test case to declare the Equal Access Act constitutional under the Establishment Clause of the First Amendment, stating that, quote unquote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The constitutional issue is that the Establishment Clause of the First Amendment is a doctrine of separation of church and state. Therefore, schools must adopt a neutral position in regard to religion. It poses a question: does the Equal Access Law put schools in a position in which they would have to provide access to any group? The Supreme Court ruled in favor of Bridget with an 8-1 margin. Justice Sandra Day O'Connor declared, quote unquote, a high school does not have to permit extracurricular activities, but when it does, the school is bound by the Equal Access Act of 1984. If a public school allows clubs tied to the school's curriculum, such as French club and math club, it can exclude clubs not related to its educational mission. But once a school allows student interest clubs, such as environmental club and chess club, it cannot exclude religious clubs or political clubs. However, if the club is religious, the school must refrain from active involvement or sponsorship. Before I end this video, I would like to mention a connection I made with the Equal Access Act. To me, it is similar to the Equal Protection Clause. The Equal Access Act is for federally funded secondary schools to provide equal access to extracurricular student clubs. Basically, they cannot exclude clubs just because it's religious or political. The Equal Protection Clause is the idea that a governmental body may not deny people equal protection of its governing laws. Basically, the governing body states must treat an individual in the same manner as other in similar conditions or circumstances, which is supposed to eliminate discrimination. The bottom line of the West Side Community Schools versus Mergens is that public schools that allow student interest clubs cannot exclude religious or political ones.